The reason I asked you all to come here today was this morning I filed with the Oakland County Circuit Court a motion, a 178-page motion with attachments. And the purpose of that motion was to ask the Oakland County Circuit Court to remove and disqualify the Oakland County Prosecutor, Karen McDonald, and her entire office from further prosecuting the case of the Crumbleys in any way, shape, or form. So why is that important? Well, we obviously have a motion pending now in the court for a new trial and for an acquittal. There's obviously going to be appeals. It is my position that the Oakland County Prosecutor has demonstrated that she is unable to prosecute this case consistent with the constitutional, legal, and ethical rules that are imposed on her office. So I'd like to talk to you today about what in particular is the basis of my motion. You may have heard me say before at court, I have described the prosecution's actions in this case as exemplifying a pattern of cheat and deceit. And I do stand by that claim, and I do stand by those words. And today I'd like to show you exactly what I mean by that when I talk about cheat and deceit. When we were in court in the end of January, we talked a lot about the secret agreements that came to light. We found out after the trials that the Oakland County Prosecutor had entered into 2 agreements with their key witnesses, the school officials from Oxford. And those witnesses received a form of use immunity. What does that mean? It means that they asked them to come in and talk to the prosecutors with the understanding and the agreement that anything that those witnesses said could not be used against them in any criminal proceeding. All right? The prosecution has continued to deny, and to be honest, they have just outright lied about their obligation and duty to produce those profer agreements to the defense. It is our position that the jury should have been made aware that those witnesses were testifying pursuant to these immunity agreements, and that if the jury would have known that, they certainly could have reached a different outcome in the case. So while we have talked about the suppression by the prosecution of those profer agreements, what I want to make clear today, and what is made clear in my filing this morning, is that is, in my professional legal opinion, that is an ethical violation on the part of the prosecutor's office, that they declined and refused to produce those agreements. I'd like to show you a rule of ethics. This is Michigan Rule of Professional Conduct 3.8, and I'm going to have Jackson show that to you. So let's just talk about what these ethical rules are. First off, all of us as lawyers, we are officers of the court. We are bound by a code of ethics. There is a book of ethical rules that apply to all lawyers when we present cases in court. However, what you should understand is that there is a separate and special set of ethical rules that apply specifically to the prosecutor. So what I'm saying is that in addition to all of the rules of the ethical rules, there are special rules that apply specifically to the prosecutor. And this is what I have up here to show you. Jackson, if you move up to the top. This is Michigan Rule of Professional Conduct 3.8. And you'll see it says special responsibilities of a prosecutor. So first off, why do we have these ethical rules that bound the prosecutors? I will tell you why. Because we understand the judicial system and the criminal justice system has evolved in a manner that we understand that the prosecutors have vast resources at their disposal. And so in order to make sure we keep a level playing field, these rules of ethics were put into place so that we maintain a level playing field for all litigants who come into court who are accused of crimes. And by virtue of ignoring these ethical rules, it is my position that the prosecutor created an unequal playing field with the defendants in this case. If you look at 3.8D in particular, it talks about the prosecutor has a duty to make timely disclosure of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the degree of the offense. The prosecutors violated this rule, MRPC 3.8D, and they did so by withholding those profer agreements and keeping them secret at all times before and during the trial of Mrs. Crumbley. That is the first ethical violation. Now, if you were at court last time, you may have heard me talk about something called Brady. We have a U.S. Supreme Court decision from 1963, Brady versus Maryland. All lawyers know it, judges know it, law students know it. The case of Brady versus Maryland established the principle as a constitutional rule that the prosecution is duty-bound to turn over any favorable discovery. So, when I first started this press conference and I told you that the prosecutor has committed both constitutional, legal, and ethical violations, the constitutional violation is certainly found in the violation of the Brady rule. Now, we've talked about the ethical violation that arises from the imposition of the duty under MRPC 3.8D, all right? So that is the first ethical violation that we've presented to the court. However, and you've heard a lot about the profer agreements, but today what I really want to talk more about is the other way in which the Oakland County prosecutor violated the rules of ethics. And she did so by using taxpayer-funded public relations firms that were hired in secret by the prosecutor's office. And they hired the first one of those PR firms within hours of the shooting. Within hours of the shooting at Oxford, the prosecution had already retained the first of the public relations firms by the name of Identity. Now, what I have recently obtained, and I'd like to show you, if Jackson would bring up that invoice for Identity. I didn't know until just recently how much money the Oakland County prosecutor had spent on this first public relations firm, Identity. I now have the invoice. That's what I'm going to show you. $35,893.25. No, I want the invoice. Please go back to the invoice. $35,893. And if you move down, this is important because this was approved by the Oakland County prosecutor's first chief assistant, David Williams. Why is that important? Because the prosecutor's office has publicly said a few things that are false. They have said, one, that, well, Oakland County approved the use of these firms. No, that's not what happened. The Oakland County prosecutor asked for $1 million from Oakland County to prosecute these cases. $1 million. Think about that, $1 million put into a case to prosecute a couple from the community with very little resources. They didn't stand a chance. This is how they created an unequal playing field. They did it by use of these public relations firms that serve the purpose of spinning the narrative in favor of what the prosecutors wanted to have heard by the public. All right? So not only is that abnormal, because you won't see that anywhere. I haven't seen it. None of my colleagues have seen it. And I've talked to a lot of practicing attorneys like myself around the country. Nobody has seen a prosecutor's office do what the Oakland County prosecutor's office has done in this case by retaining these public relations firms. But it's not just that it is out of the ordinary or abnormal. It is unethical. It's not just a matter of this being strange. This is unethical, all right? And I'd like to show you the rule of professional conduct that governs this particular claim. This is MRPC 3.8. MRPC 3.8E. And E says the prosecutors are supposed to take care to prevent investigators, law enforcement employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under 3.6. All right, we're going to look at MRPC 3.6 here in just a second. But what this rule does, it has the practical effect of placing a prohibition on the prosecutor from using agents or other people or public relations firms to do or to say what she could not do or say directly. All right? That is a violation of the rules of professional conduct, and it is an ethical violation that has been committed by the Oakland County prosecutor. So, if you ask me, well, what does Rule 3.6 say? We're going to take a look at that, and this is where you can look at it in a finer light to see what exactly the prosecutor did to publish and push a negative narrative about the Crumbleys. All right, now 3.6 tells you that a lawyer who's participating in a case, it says, shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. And then it tells you what types of statements would have a substantial likelihood of prejudicing the case. And it says, any statements that relate to, in a criminal case, the character, credibility, reputation of a party to a case. All right? So it is my position that what the Oakland County prosecutor did in this case was she used PR firms and social media influencers to push negative information about the characters of the Crumbleys. And that is a direct violation of MRPC 3.8 in conjunction with MRPC 3.6, which we've just read on the board. Now, the prosecutor's office has said, well, this is wrong, we didn't do this, what Deszi's alleging isn't correct, we needed those PR firms just to, quote, get out the facts. That is a lie, all right? It is a lie, and I'm going to show you how I can prove it was a lie. We could take a look at Exhibit O from the Identity's website. All right, this is from Identity's website. They bragged about what they did and their work with the prosecutor's office. Now, this is real important. They said here that they prepared and 6 reports were delivered between November 30th and December 4th, summarizing all the press coverage and digital discussions which shaped how announcements were planned. By monitoring the national conversation, Identity provided thoughtful, relevant insight into how key political figures and the general public were responding to the crisis. What does that mean? It means they ran a smear campaign using public relations firms who then bragged about what they did on their own website. So this is not simply the prosecution saying, well, we needed to get the facts out. No, they wanted to get their facts out, and the facts they wanted to get out were the negative facts about the Crumbleys and their characters. Direct ethical violations of MRPC 3.8 and 3.6. Now, if I were you, you guys should be asking, what's in those 6 reports? Because I sure would like to see them, and I've been trying to get them. I don't have them as of now. I intend to get them. I will get them. If any of you get those 6 reports, you know where to find me. Because what I believe we're going to find is that these PR firms were telling the prosecutor's office what points were the most negative, what points were being repeated the most often in the atmosphere, the social media sphere, so that they could then focus and refocus their narrative and their talking points about the Crumbleys leading up till the trial, all right? These 6 reports, I have asked the court in my motion this morning, I have asked the court to give me subpoena power so that I can send subpoenas to these public relations firms to obtain all of these documents, including these 6 reports. I will also tell you guys that I believe the PR companies use spam bots to push these negative narratives about the Crumleys. And when we do get these documents, they're going to be eye-popping, I promise you. What you're not going to see in those documents is simply some documents saying, this is the facts we wanted to get out. That's not what you're going to find. And that's why, ladies and gentlemen, they're not producing those documents in reports. But again, I have asked the Oakland County Circuit Court for subpoena power to obtain all of those reports and documents so that we can fully understand and appreciate the depths of their dishonesty and the deceit that they carried out in this case, which was improper from the very beginning. Now, what's even more interesting is I just uncovered the receipts of their payments showing that they're still paying the public relations firms. If Jackson, if you could pull up the invoices for a moment. Nope. Nope. It's yeah, right there. All right. So here's an invoice dated 1/9/2024. This is from Moment Strategies, and they billed the Oakland County Prosecutor $3,762.50 in that month. Now, what you're going to see, I have all of the invoices, all right? What you're going to see is that these invoices, they increased substantially leading up to and during the trials of the Crumleys. Jackson, can you, here's 3 of 24. So here's 3 of 24. That was the month, I believe, of James's trial. Now they're up to $5,800 for their monthly billing, which they put down as communications consulting services. Communications consulting. I don't know what that means. What it means is it wasn't proper and it was unethical. That's what it means. Now, this is important because while the prosecutor is saying, well, we just had to put these facts out and that's why we had to use these PR firms. No, that's a lie. They used those PR firms and they ramped up the smear campaign during the months of the trial. Well, why would they do that? Gee, I wonder. Because they were pressing the public with their negative opinions and negative narratives during the trial while jurors were sitting in court hearing evidence. They interfered with the process of the criminal justice system by interfering with the trials during the actual time that these trials were underway. And these receipts will show that. Because as I said, the amounts that they billed increased for the months of the trials. Now, Jackson, if you can take it to the most recent, you're also going to see they're still paying these public relations firms. All right? So we have 3 of 25, March of 2025. Am I reading that right? Yep. Yeah. Well, this was billing for January of 2025, due on March. They're still billing $1,400 a month to the prosecutor's office. I mean, this looks like a money grab or a taxpayer giveaway to these public relations firms that have no place in the criminal justice system. No place. And a prosecutor is absolutely prohibited from doing what they did in this case. And that is why we are asking that the Oakland County prosecutor be removed and disqualified from the case for any and all further proceedings because of the ethical violations that we've just looked at. Now, apart from the ethical violations, let's just take a look at the Moment Strategies contract too. I just want to show them that. The Moment Strategies, the Moment Strategies contract, that's right here. This was authorized, a contract for $100,000 for Moment Strategies. And this contract date, look at this, January of 2022. They had this set up from the minute this case got started. They put all of the machinations in place that they needed to ensure they could spin a negative narrative on the public and just keep pushing and pushing and pressing it. And you know what, ladies and gentlemen? It's not hard to see what they did. You just have to go back and look at the news articles from the time period. And if we're wondering, well, did these news articles comment on the character and reputation of the Crumbleys? Absolutely they did. That was the point of it. And that's why I call it a smear campaign, right? And to the extent that they deny it, you know what I say? Then show us the documents. Show us those documents. If you want to deny it, give us all those documents. Give us the 6 reports that Identity wrote and delivered to you, I guess to help you figure out how best to try your case against this couple from the community. Remember, $1 million they had to spend on this. If you add up these invoices, my count is somewhere close to $150,000 if you add up the contract for Moment as well as the Identity, the other Identity PR firm. This is on top of the fact that we also have now learned that the prosecutor turned the Oakland County Prosecutor's Office into some makeshift Hollywood film set with documentarians and film crew in the back listening in on strategy meetings about how best they could try their case. Now, why in the world would a prosecutor need to have Hollywood producers in the back with them talking about their case and discussing what they should do and how they were going to do it? No, ladies and gentlemen, it is my position that the use of those Hollywood-style production companies, that was to glorify the prosecution's actions and to make them look better and to make them look good in the eyes of the public after having this vast amount of resources that they bestowed upon this case to try and successfully convict the Crumbleys. All right? That is unprecedented. It is unethical. Those are violations of the constitutional principles that govern these proceedings. Those are violations of the court rules. And most importantly, for purposes of what was filed today, those are ethical violations under Michigan law. So I have asked the court and I have asked the judge, one, to give me subpoena power to get all of those documents so we can completely understand and discern exactly what they did and how they did it. And I'll say it again. I do believe they used spam bots in this case. All right? So let's see. We'll get those documents and we'll see if I'm right. Right? For these reasons, I am convinced the Oakland County prosecutor cannot and should not be trusted to prosecute this case in any shape or form moving forward, whether it be for purposes of appeal, for purposes of a retrial, or anything else. I have asked the court to remove the Oakland County prosecutor and her entire office. Why is that? Because there is case law in Michigan that says if the county prosecutor is disqualified or removed from a case, their entire office has to also be removed from the case. Why? Because they are all subordinates to the prosecutor. They are employees of the prosecutor. So the law recognizes that there is an inherent conflict between the prosecutor and her subordinates such that they all have to be removed. I would also just point out that Michigan law does provide for a procedure by which to appoint a special prosecutor, and that is what I'm asking the court to do in this case, is to remove the prosecutor and then to appoint a special prosecutor moving forward. I don't believe the prosecutor should be involved in this case, given that she has demonstrated she is unable to prosecute this case consistent with the constitutional, legal, and ethical rules that we have discussed here today. If anyone has any questions, I'm happy to answer them.
So how does this differ from the motion that was filed last month?
Yeah, so the motion that was filed the motion that was filed was a motion for a judgment of acquittal or a new trial. And I had just recently obtained some of these documents, so there's not any affirmative request in that motion to remove the prosecutor, right? So the judge's options on that motion are either to grant the new trial, grant a judgment of acquittal, or just deny the motion. Regardless of what she does, I'm now asking for the additional remedy that the prosecutor's office be removed from the case. So that's not at issue currently in the motion. Anyone else?
As I understand it, the prosecutor has contended no immunity was promised in the case.
They're wrong. They don't know what immunity is then.
Well, but, you know, does this change the facts of the meeting with school officials the morning of the shootings and what your client withheld from school officials as far as gun access and behavior?
Well, I don't think my client withheld anything. She was not asked specific questions, nor was she aware of what they were thinking or looking for. The point of why these agreements are necessary to be displayed is because when these individuals from the school were negatively describing the Crumbley's meeting, you know, that was their subjective impressions of what they said happened. And when the jury heard that, they should have also heard that those guys were running from criminal prosecution. So they were incentivized to try to say those things because they wanted to please the prosecution so that they would not be charged. So that's the import of why those agreements are necessary. Now, the jury certainly was free to decide what facts they found to be the most important, but they were deprived of those facts because those agreements were hidden.
But procedurally, if she says, McDonald, that there was no immunity granted, you say you disagree. Can you take us a layer deeper on why she's wrong?
Well, first off, I think the judge expressed her opinion during court that she was in agreement with me that there was a discovery violation, okay? And that the violation was of MCR 6.201. That's a court rule that says when the defendants request it, the prosecution has to provide any agreements for immunity or any other agreements. So whether it is actually an immunity agreement or just some other agreement, either way it had to be produced. So that's why, in my opinion, I'm not going to speak for the judge, she tended to agree with me in court that there was a violation of the rules. Now, she's still considering the proper remedy for the violation, but I don't think the court had any trouble understanding and accepting the proposition that those agreements were supposed to be turned over.
Do you have any idea on timing on her decision, the judges, in regard to a potential retrial?
I do not. The judges don't answer to me, unfortunately. I don't know. We're waiting for a decision.
how would you explain to the general public who is not watching this closely, but they're seeing, you know, the news headlines that motion after motion is being filed? Can you explain just what is going on?
Yeah, so, well, if there's a trial and there's a verdict, once that verdict is entered, a litigant in a proceeding like Mrs. Crumbley has a right to file certain motions and appeals. And Mrs. Crumbley has an absolute right to appeal her sentence and her conviction. As part of those appellate rules, she's also permitted to file a motion for a new trial. So those are pretty much standard motions if there is a basis, and we believe we have presented several bases. While the judge may have disagreed on several of the bases of the motion, she has not yet ruled on the basis regarding the proffer agreement. So, I mean, these motions are standard and somewhat typical motions that are filed post-trial, if there's a basis, which of course we believe there is. Anyone else?
Can you revisit real quick the PR firm aspect, ethical questions aside? This was a groundbreaking case, never had been prosecuted before successfully. I'm not endorsing, but I'm asking what's wrong with hiring PR firms in this type of an exceptional circumstance?
Well, the type of case doesn't allow us to ignore the rule, all right? It doesn't matter if it's a case of Microsoft versus Google worth billions of dollars, or whether it's a case of involuntary manslaughter in Oakland County. The rules are the rules, and the rules are clear. And the rules of professional conduct say the prosecutor can't use somebody else to disseminate information about a defendant's character. So the nature of the case is, if you understand in context, the nature of the case is irrelevant to what they did. They can't do it. It doesn't matter to me what kind of case it is. You know, the way it normally would happen is the court has a press person, press spokesman, and that person would simply answer questions and say, no comment. So that's not what they did here, because as I've showed you, they were drafting reports, they were giving them recommendations about the narrative, crafting the messaging. So they were looking at what was happening in the public, and they were synthesizing that down into, okay, these are the most negative points it seems like that the public is interested in, so push those points. Make that your narrative. That's what they did, right? And it doesn't matter what kind of case it is. They can't do it.
Are you alleging they were trying to taint a jury pool?
Yeah. Oh, yeah. I'm alleging that they created an unequal playing field. I'm alleging that they tainted the jury pool, and I'm also alleging that they added additional pressure to the trial itself and to the jurors' deliberations by ramping up the smear campaign in the months of the trials. And we've seen that by virtue of the fact that those invoices, they increased the amounts of their billings during the months of the trials.
And so just to clarify, so in total, how much are you saying was paid to each of the PR firms?
Well, that's a little bit of a moving target. So I have the $100,000 contract with Moment Strategies, and I now have the $35,000 or $36,000 contract with Identity. So we know we can add those up, 136. But then there's a number of other billings. So it's not clear to me whether those other invoices or billings were within the 100 or they were in addition to the 100. So it could be 180,000 or so if you add all those up, or it could be 136,000 if you don't add the invoices on top of the 136. Does that make sense?
I think so, and with Identity, the $36,000, that was the maximum contract?
I don't know. That was the amount that was paid and approved by the prosecutor's chief assistant. But if there's more, I don't have them yet. So just so you guys understand, Oakland County has been very slow to produce these documents, right? I wonder why. Yeah. Anybody else? All right. Thank you all for coming. I appreciate your time.
Thank you.
All right. If anybody needs copies of any of these, you could see Jackson and he'll make sure he emails to you what you're looking for. If you need them, just give him an email address and then Jackson will get you the documents you're looking for.